Goolsby, for what purpose do you rise?
I rise to speak in support of the veto override.
You have the floor.
Thank you, Mr. President. Ladies and gentlemen of the Senate, I've heard a lot of talk today. I'm actually a criminal defense attorney, been one for about 20 years, the entire time I've practiced law. I was in criminal court this morning. I've dealt with cases where I've been concerned about juror bias, and we currently have something under the law, U.S. Supreme Court, called a Batson test. It's a three-prong test. Any attorney who doesn't do that, particularly in a death penalty case where they're representing a minority defendant, will very quickly find a motion filed against them if that person's convicted for ineffective assistance of counsel. That test, under North Carolina law, is a three-prong test, actually under federal law, constitutional law. A defendant making a Batson motion must establish prima facie case of discrimination. That's the first thing you do when one of those motions is heard in criminal court. Second, if the defendant's successful in establishing prima facie showing of discrimination, that means taking a black person off the jury because they're black and it's a black defendant, then the state has the requirement to proffer a race-neutral reason for the strike. Then there is a third requirement under the law, and that requirement is the trial court then assesses the state's proffered reason and determines whether or not the defendant proved purposeful discrimination. Now, I've heard a lot of talk about, just people being taken off juries willy-nilly to make sure a prosecutor gets a conviction. That's not my experience over 20 years. As a defense attorney representing people accused of crimes, I've always fought hard, and I've always done that. I've never felt like I've been treated that way, or I've always had a good hearing to see to it that that's brought out on the record. So if anybody tells you that's not the way our courts currently function, they don't know what they're talking about. Okay, we already have those protections in place. Mark Twain was fond of quoting Benjamin Disraeli, a British prime minister back about a century ago or more, of saying their lies, their damned lies, and then their statistics. What we're dealing with here is a whole different thing. If you all heard Skip Stam, the prime mover of this bill over in the House, speak, he said, since the Justinian Code was created 1,000+ years ago, we have not gone after people as a group. We don't group people in this country. We go after people based upon the crimes they committed. I saw a number of you here at the meeting that the district attorneys had with the victims many weeks ago when we first heard the modification of this legislation. What did you hear? You heard stories like good Senator East's that would bring tears to your eyes, both from white victims' families and from black victims' families. There's no question that the people we're talking about committed murder, were convicted in courtrooms of murder, and were sentenced to death in courtrooms of murder. Now we're talking about Monday morning quarterbacking on a whole new extreme, looking at statistics alone in order to do that. That should disturb you. That should disturb you greatly. That is something no other state does. Even Kentucky, which has something called a Racial Justice Act, does not come anywhere close to the audacity of this bill. And let's talk about the district attorneys in this state. Every district attorney, just about except for one, maybe two, support the modifications that are in the bill that we sent to the governor that she vetoed that I urge you to override today. They called it a farce. In fact, when I was quoted, when I stood up and presented this bill before this body back several months ago, on National Public Radio, they quoted me, and at remarks I made, I said that the Racial Justice Act as currently conceived is a backdoor attempt, a Trojan horse, to get rid of the death penalty in North Carolina. What was immediately following my remarks? Something you've heard a couple of times today. Look at the Innocence Commission, where people were literally improperly convicted and put on death row, and they were released. Well, folks, that's a non sequitur. We're not talking about the Innocence Commission. In fact, the prime mover of that, a Republican Supreme Court Justice Beverly Lake. We're not talking about the Innocence Commission. We're not talking about DNA evidence. We're not talking about people who are not properly convicted of murder. That doesn't even follow. That's what really bothered me about that article. They compared the modifications to the Racial Justice Act of improper DNA evidence. Those don't follow. Those don't compute. Those don't go together. Those are two completely different things. Racial Justice Act says we've got people convicted of murder, and now we're going to turn around and see if we can find some statistical anomaly to say that for some reason, even though they committed the murder, they shouldn't be put to death. Governor Perdue is deep in hypocrisy, I believe, in her overturning or her attempted to veto this bill. My office, we called the Attorney General's office to see where he was. I noticed he's been conspicuously absent in all of this. Has anybody seen him over here? Did he show up when the district attorneys were here talking about it with the victims? We called his office to see what he had to say about it. And this is what we got. We called, spoke to a liaison over at the Department of Justice. He declined to comment due to the possibility that the Attorney General's office will litigate cases involving the Racial Justice Act appeal. The liaison said the Attorney General is responsible for defending the constitutionality of state laws, so he'll not participate in this public policy debate with the legislative and the executive branches. Well, you know, it's really strange because I got a letter right here where when we passed House Bill 2, that was the bill passed in the House and Senate that asked our Attorney General to stand up and fight Obamacare. Well, he was real happy to produce an opinion, actually 2 different opinions, a letter and then a whole legal brief and then a second letter, and made all sorts of comments to anyone who would listen that what we're doing's wrong. He won't stand up at all and fight on this. And I say, where is our Attorney General? Why is he not standing up for the victims of crime? Why is he not standing with our district attorneys across this state? Why is he not saying anything about this? That is of deep concern to me as a lawyer, wanting to know where our Attorney General is on this. Every member in this legislature knows that this is a backdoor attempt. This is a farce, an attempt to get rid of our death penalty in North Carolina. And I tell you, the most damning piece of evidence we have here, I saw to it that my staff put it on your desk. It's a letter dated December 15 of this year, or this past year. And it is from the district attorney from Lincoln and Cleveland counties, Richard Schaefer, who happens to be a Democrat, as I understand. And I just want to cite to you a few things from his letter. Dear Governor Perdue, I regret to inform you that I am resigning from my position as a member of the Governor's Crime Commission. My resignation is effective immediately. Third paragraph. I'm resigning from the commission as a result of your decision to veto the recent amendment to the Racial Justice Act. While my district does not have any cases that are subject to the Racial Justice Act motions, the impact of the law as it currently stands is tremendous and devastating. Fourth paragraph toward the end, last sentence. By your decision, you have at a minimum further delayed victims' right to justice. In the worst case scenario, if the worst case scenario takes place, you will have helped unleash violent murderers back into society. Next paragraph. I want you to carefully watch any case where a racial justice motion is granted, if one is ever granted, and see how long it takes for an attorney paid for by North Carolina prison legal services, that's the taxpayers in North Carolina, that's us, or similar organizations to file a motion seeking the release of the prisoner based on the argument that the sentence submitted under the Racial Justice Act is illegal. These are the same people who made the argument that the statute protects us from that event. And I don't care what you've heard, the case law that I've seen, what I've read, how in the world, ex post facto, do you take someone and just write into a bill that if we grant you relief under the Racial Justice Act, we're going to increase your punishment to life without parole, when they were sentenced to either the death penalty under the prior 1994 law, or under that law, they would get life with parole. I don't know how that computes, and I've seen all these opinions, but I've also read the other opinions. Why do we even have to go there? Further, he says, you should have no doubt we will fight your efforts to release them. But the state should not have been placed in this position to do so by the initial legislation, nor you. Don't bother to engage in an effort similar to that undertaken if the lifers end up being released. You have no moral authority to take such action in any case if a party is released as a result of prevailing in a racial justice motion. And lastly, the next paragraph at the end. Your decision simply gives the anti-death penalty supporters indirectly what they cannot get directly, which is a repeal of the death penalty. You no longer have any moral authority to suggest that you strongly support the death penalty. Your action has shown that particular statement to be untrue. He called the governor out, and I agree with him. And I urge you to vote to override the governor's veto in this matter. Thank you.
Any further debate?